5, 4, 3, 2, 1.
It would appear from these provisions that the seizure of the said vehicles was carried out with jurisdiction, and the order of confiscation was also made stop. It is also possible to contend that as the said vehicles were sold pursuant to a judicial order, no liability can be attached on the state government for their disposal by public auction stock, but between their seizure and the auction, there was a duty implicit from the provisions of the Act to take reasonable care of the property seized stock. This is so because the order of confiscation was not final and was subject to an appeal and a revision before the revenue tribunal stop. State was aware that the order of seizure and confiscation was not final, being subject to an appeal, and was liable to be set aside either in appeal or in revision stop. It was also aware that if the said order was set aside, the property would have to be returned to the owner in the same state in which it was seized stock. In spite of this clear position, the appeal was still pending before the revenue tribunal, and without waiting for its disposal, it allowed to have its disposed of an unclaimed property stock. The state government was fully aware by reason of the pendency of the appeal stop. The vehicles were and could not be said to be unclaimed property stock. In these circumstances, the state government was under a statutory duty to take reasonable care of the said vehicles which were liable to be returned to their owner stop. Once the order of seizure and confiscation was held to be wrong, the respondent could rely on that obligation and claim the return of the said vehicles stock. On behalf of the respondent, the contention urged was that the seizure might be lawful, but the state government was in a position of a bailee and was therefore bound to take reasonable care of the said vehicles stock. No such reasonable care was taken, and the vehicles remained totally uncared stock. State filed the reply that there was no bailment, nor can such bailment be inferred stop. It can arise only under a contract between the parties stop. This contention is not sustainable stop. Bailment is dealt only in cases where it arises from a contract, but it is not correct to say that there cannot be a bailment without an enforceable contract stop. It is not necessary to incorporate into the agreement and to prove a consideration stop over.